Hello and welcome to Big Picture. I am Vishal Dahiya and today we will take up the issue of one candidate, one seat. The centre government has opposed Election Commission's proposal to bar a candidate from contesting from two assembly or parliamentary constituencies during elections. In its affidavit filed in the Supreme Court on Monday, Centre has said that amending Section 33(7) of the Representation of the People's Act 1951 may cause the infringement of the rights of the candidates contesting elections, as well as it may curtail the choice of candidates to the polity. Earlier in April, the Election Commission in its affidavit had said that it had made a proposal to the government in 2004 and 2016 to amend the provisions of the concerned act to restrict the contest from one constituency. Over the years, several leaders have contested from two constituencies in Lok Sabha and Assembly polls. Some had even contested from 3 seats till 1996, when an amendment to the Representation of the People's Act 1951 restricted it to 2 seats. This issue has been debated in public domain for quite some time now, and for a detailed discussion today on this, we have with us a distinguished panel of guests. Let me start by introducing them to you, beginning with we have with us our former Law Secretary, Mr. P.K. Malhotra. We have with us former Chief Election Commissioner, Mr. S.Y. Quraishi, and senior journalist, Mr. Shekhar Iyer as well. Welcome all of you to Rajya Sabha TV studios. Let me begin with you, Mr. Bhardwaj, to try and understand what does this affidavit which has been filed by the centre clearly means in layman's terms, because legally it looks like that the centre has taken a divergent stand than that was taken by the Election Commission on this issue.
This issue has been under consideration for more than 1.5 decades. There has been demand that a candidate should be allowed to contest only from one seat, because a lot of money is wasted on the election. In case he wins from the 2 constituencies, in one of the constituencies you have to hold a re-election, then voters are also put to inconvenience. And therefore the Law Commission in its previous report, as well as the report given in 2015, recommended that this law should be amended. But as on today, so far as the Act is concerned, it makes a provision, so legally a candidate can contest from 2 seats. Now, talking from the political parties' point of view, I think there is a reason why political parties want, because you will find that normally it is the senior leaders of the party who contest from 2 seats, not the ordinary candidates. And there are reasons. One reason can be they are not very sure that if they contest from 1 seat and they lose the election, because they are the senior leader of the party, it will adversely affect the political party as such. And if they win from both the seats, then probably they say that we enjoy a good reputation and see our leaders can win outside their normal home constituency also.
Okay.
I think these are the main reasons for which the political parties and the senior leaders of the political party contest from 2 different constituencies.
Okay, we'll go into the political aspect of it a little later, but let's first look into the merits and otherwise of this particular argument, and let's bring in Mr. S.Y. Quraishi. Mr. Quraishi, Election Commission constantly has been maintaining that this provision should be done away with. In 2004 as well as in 2016, the recommendations of the ECI to the government were similar in nature, as has been the affidavit which was filed by them in Supreme Court this time around. So what is exactly the basis of the Election Commission's arguments and its suggestions to the government as well as to the court?
You know, Election Commission, the recommendation is based on common sense. There is a constituency people should contest from. If they contest from 2 constituencies for their ego reason, that they want to show that they are very popular, as Mr. Malhotra said, or they are not sure because their entire future, it is only the top leaders who think their entire future hangs in balance. If they lose from that constituency, they lose all their prospects. Therefore, they contest from 2 constituencies. They are playing with the sentiments of the voters. A voter votes for me, elects me, and suddenly I resign, and within 3 months another election is held. So therefore, number one, if the reason for which they contest from 2 elections goes against the sentiment of the people and against the common sense, why should they contest from 2? Secondly, I would also say the government is very confused On the one hand, such a serious debate is going on simultaneous election. Now examine all the logic for simultaneous election, that because of frequent elections, people are tired. Now, frequently, if people are tired and the prolonged model code of conduct disrupt the entire development process, now what will happen when an election is repeated within 3 months? What happened to the prolonged model code? What happened to the people, the election fatigue? They forget about it. So, what is this? Is double speak? Double standard?
But Mr. Quraishi, in its affidavit, the centre has said that this entire process falls into the ambit of electoral reforms, and electoral reforms is a complex process. There have been recommendations which have been made by Election Commission as well, but since it would require amendment of several acts, maybe it would require a consensus amongst the political parties, so it cannot be taken just one issue at a time. We will have to look at the entire issue of electoral reforms in a holistic manner.
So, what is stopping them from doing it? They are only talking of simultaneous elections. That is a major reform, no doubt, which requires consensus. Now, what is stopping them from doing the comprehensive discussion in electoral reform? There are 40 reform proposals of Election Commission pending for the last 20-25 years. So, what is this piecemeal consensus and all that we keep hearing? So, do it. If it requires consensus, please call a meeting, start the consensus process. Why are you not doing the consultation? Only piecemeal, whatever apparently suits them. Now, that is obviously, this puts a question mark on the moral authority.
Okay. Let's bring in Mr. Iyer here. Mr. Iyer, you've seen political parties closely. You've covered them as well throughout your career. What exactly, taking away from both our panelists' point of view as to the reasons why the political parties might be interested in continuing with that and the reasons which have been given by the Election Commission, which side weighs much tougher and higher?
You see, even in the centre's affidavit that they have filed in the Supreme Court, they are saying leave it to the wisdom of Parliament, saying that it is Parliament which had decided in 1996 to restrict it to 2A. But I think obviously the political class is resistant to this particular reform. In this particular, of course, they are resistant to many other reforms suggested by Election Commission. They are resistant to this. Whichever party, they feel, as was pointed out here, one, to show that they are popular, so they can contest from north and south or east or west or whatever. Second is the search for the safe seat, which is a tendency very common to protect the image of the whoever is leading the party. This is one trend. And third argument that is often given is, if you get some senior leader to contest from a particular constituency, it has some kind of effect, a ripple effect affecting other constituencies. But I would rather be more concerned with the voters' point of view, which was also mentioned here, which is, you see, if I am a voter of a particular constituency, I am going to vote for X person, belong X party, thinking that this person is going to represent my constituency, he will do for the welfare of this constituency, so I vote. Now, when a candidate is already contesting from two constituencies, you are confusing the voters, because voter knows that he has to leave one constituency as soon as the results are declared. Therefore, at the heart of it, if you see, I mean, forgetting the legal and other things, somewhere along this goes to betray the voters' confidence, because ultimately he can represent only one constituency. So, but the political class is resistant to it. Therefore, I think within the Parliament there should be a debate. You see, after all, you can represent only one, even if you can contest two. But when the law is already clear, why should people of one constituency, whichever constituency, they will be deprived of whatever choice they made, because they are also making a choice. And if election is about choices, this is not a very fair choice that you are allowing voters.
But the counter argument which Centre has given in its affidavit to the Supreme Court on Monday is that if you go ahead and amend the 33(7) of the Representation of the People's Act, then you would be restricting the voters' choice of the polity, because one person now who can contest from 2 seats will not be able to do so.
No, but in any case, you see, is it about the candidate's choice or is it about voters' choice? If you do away with the provision, it takes away only the candidate's choice, because the voter knows ultimately he can choose only one. And that one, and if that candidate is going to contest from any other place, he is not sure which constituency he is going to give up.
Okay.
Because the interest of political parties, interest of the political leaders who are contesting is exactly not coinciding with the interest of the voter, because voter is exercising a choice. He has to make a choice among the candidates, and if he is not sure about the particular candidate, though he is voting for him in the hope that he will stay on, I think we are bringing in a lot of element of uncertainty in what should be a very sure, clear case, where you elect a person who clears the first post past the system.
Okay,
but political class are united on this. You see, even the centre's argument is you leave it to the wisdom of Parliament, because it is after Parliament which is going to amend it. Even if today, assuming that this process goes to final hearing in the Supreme Court and Supreme Court comes with the verdict, assuming a scenario where it says, well, it says, no, you cannot have this law. Now, it will again go back to Parliament, and Parliament, the political class is more likely to unite, saying that this is a choice that should be left to Parliament.
Okay.
So the debate could rather go turn to Parliament powers versus the judicial pronouncement.
Okay, so there are several complexities involved here, but let me bring in again somebody who has been with the law ministry. Sir, if you look at the legal aspect of it, clearly you also spoke about, and the former election commissioner also pointed out. But if we weigh the pros and cons, legally speaking as well as constitutionally speaking, one, we understand that it's a complex process, but how difficult it would be for any government of the day to go ahead and get it done, one, and two, what might be the most suitable argument out of the ones given by the election commission?
You see, we have very rightly said, it has a legal implications, it has a legal angle. That legal angle is under consideration of the Supreme Court in the PIL, which is pending, and where this affidavit has been filed by the government. Now, government as a matter of policy has to decide whether the present provision should be continued or not. Now, so far as the legality is concerned, matter is pending before the Supreme Court. So far as legality is concerned, matter is pending before the Supreme Court, and Supreme Court has to see whether the provision is constitutionally sustainable or not. Whether it violates any of the provision of the Constitution, that is one issue. But second, as I said, it is from the policy angle, and from policy angle, this issue is being debated for the last more than 2 decades. So if you are going to take that long to decide a policy decision, I think there is a big question mark on that, and probably as a policy matter also, you should not take that long to take a call on the issue which is pending and which is being debated, and which is a concern of the larger interest of the public. And I personally feel that it has been rightly said, it is for the Parliament to decide, but in the Parliament, because all political parties are there, and political parties, because probably they are little comfortable with the provision or the amendments which has been suggested by the Law Commission, probably they are taking little longer than it is expected that they will take to take a decision in this particular matter.
Well, ultimately it is Parliament's domain, and Parliament is supreme. But if we again go back to the pros and cons and the advantages and disadvantages moving further, Mr. Quraishi, if we look at all the arguments which has been given by the Election Commission, one counter argument which has come from the critics of this particular suggestion is that the only benefit which might result is saving money.
No. That's a the childish argument. It's not saving money. Imagine there are 15 lakh voters. They come from different directions. Some of them are employed. They come from outstation. They come to vote, and to vote for in an election where a candidate is playing with the sentiment because he is a more serious candidate somewhere else. Now, 3 months later, they have to be called again. Many people will not be able to come again after 3 months. I think Mr. Malhotra will probably throw more light on it. Legally, you are taking away his right to vote by forcing him to come again in 3 months for no fault of his, because somebody is playing an ego game, or somebody is fighting for his survival. But Mr. Iyer is absolutely right. Probably the top leaders of all political parties are the guys who play this game, not the ordinary candidate, or maybe millionaires and billionaires. Basically, it is the top leaders, and they will not agree on this suggestion. They will agree among themselves. There will be a complete unity among them.
For the other candidates, the second-run candidates and all that, there is also a suggestion which was made by the Election Commission about dummy candidates and independent candidates as well, trying to restrict them as well. So does both the arguments go hand in hand, or will one of them being implemented will make that much of impact and maybe open up the ground to ensure that the second argument can also be brought?
No. The second argument is totally unrelated, because there is a problem of dummy candidates. What happens is there is a ceiling on expenditure, say for Lok Sabha 70 lakhs. Now, if I put up 3 more dummy candidates, their 70 lakhs also become available to me. They will be going in ostensibly to campaign for themselves, but they will be carrying my literature. or sometimes they put up dummy candidates of the same name. S5 Quraishi, there will be 4 S5 Quraishi contesting just to confuse the people. So that is an unrelated problem, serious in itself, that in any case probably will go through. But this one, I think the only solution will be when the voter thinks that these guys are playing with my sentiments. They are trying to prove their popularity or survival game. So my feeling is that he is more serious about that constituency. That constituency will feel he is serious about that constituency. Let us not vote for him because he is playing a game with our sentiment. So I think that is the only time when netas will learn. Otherwise, till then it will continue. And as Mr. Iyer said, they are united. They will not agree on Election Commission proposal. That's my feeling.
Well, that's part of the electoral process. That's for the people to decide, as Mr. Quraishi is pointing out. But going back to you, Mr. Iyer, if you look at the way things have moved, there were times when leaders have contested from 3 seats as well. It was restricted to 2. So that was also a decision which was taken by the political class, clearly. So if it could be brought from 3 to 2, then if the if there are more definitive arguments, it might be that in the due course of time, this argument might also be brought on board.
Yeah, they will, because you see, one thing is clear: political leaders and parties know the fact that okay, it is in the domain of Parliament or whatever, but they know that inherent in this is it's an element of not a free and fair poll, because as I said earlier, the voters, after all, you are going to the voters. Voters are making a choice, and now if you contest from a particular place just to appease, let us say, even voter sentiments. Let's say a leader is very popular; they don't want him to shift from that constituency. Even then, ultimately, you decide to change the constituency. That choice has gone waste. And at the time when we are talking of simultaneous election to save exchequer, the monetary angle also has to be looked into, because after all it's a financial burden, because immediately you have a by-election within 6 months. Now, and the tendency even among smaller parties, leaders belonging to smaller parties, to contest from more than from more than one place is also a growing trend. Because the idea is, we saw in Karnataka, even in Karnataka, where the leader thinks he is very popular, he chooses 2 places. So therefore, I think the public opinion has to build up, and the voters will have to realize, you see, this concerns the awareness of voters. After all, whom are you going to choose if he is going to shift? Now, both sides will not know, but at the same time, leaders want that kind of liberty and freedom, that they must be free to make decisions which suits the winnability of the party's candidates. And interestingly, when we see a leader contesting from more than one place, it is his rivals who criticize him more, even though they agree on the need for this provision. But during actual election time, if a senior leader contests from another constituency, his rivals are the first ones who go to town and say that, look, he is not sure, he is not popular.
Okay.
So even within the political parties, they know that this is an argument to beat their rival. So therefore, I would expect a built-up of public opinion would rather force the parties to re-examine this, because if you are talking of reforms like simultaneous polls in the name of saving exchequer, I think this is not something that political parties can ignore, because after all, this is about voters' choice, and no voter's choice should go waste.
Okay.
See, that was also the argument about nota. See, when the nota came in, the same argument was that you have to make a choice, otherwise it's a waste of the process. That's why Election Commission even devised what percentage of nota vote would be taken into declaring a particular thing null and void.
Okay, so both the panelists are pointing out that the public opinion is the last thing which might push the political class to go ahead and budge on it. But from your point of view, in terms of legal and constitutional arguments as well, what is it that might be the best possible argument which can be moved ahead to try and ensure that this might be taken on board by the government of the day, or maybe the political parties or the political class?
You see, there is one question is with regard to the legality. Even if there is something legal and permissible, the second question will be its desirability. Now, who will decide that desirability? Whether it is the Parliament or somebody else. If Parliament has to decide, again in the Parliament it is the political class which has to decide. And if the political class is unanimous on a particular point, and if it is legal, then probably it is very difficult to change it, unless the people who are the sovereign, they themselves decide to force the political class to take a decision which they want. And I
Okay.
think that is a very, very difficult proposition. When it will materialize, we don't know, unless the Supreme Court itself come to the conclusion that for certain reasons, for the reasons to be recorded, that the provision itself under Section 33, which permits contesting election from 2 constituencies, is unconstitutional.
Okay. Okay, but for the people to decide, since all three of you are putting the ball in the voters' court and all, but for the people to decide as well, once again, if Mr. Quraishi, you could list out the advantages and the basic arguments on the basis of which the Election Commission has put forth this case time and again in 2004, in 2016, now again in 2018 in its affidavit.
You know, Election Commission has been voicing this proposal not so moto, because we have been under public pressure, because people think that the Election Commission decides these things. So they tell us and they say, why do you allow such a thing? We, of course, we have to explain that it's not in our hands, it is has to be dealt with by law. But from Election Commission's point of view, after we conduct the election, that requires effort. And it takes a lot of money, but money for me has the least consideration in this case. Of course, the Election Commission proposal was that ideally you should have allow only 1 constituency, or at least put them a fine, put a fine of 10 lakhs. Now 10 lakhs is nothing. Even if you make it 50 lakhs, it goes against the principle of the people's right to vote. Some people will be denied the right to vote a second time because they won't be able to take leave from the employer and come to vote. Now, even if one person is denied that vote, I think it's a legal atrocity on him, and that is how it has to be viewed, this proposal by the Supreme Court.
Okay, Mr. Iyer?
Yeah, well, I think the arguments are, that is, when we are talking of saving money for the exchequer, I think the vote also should not go waste. And the voter must be very clear that the person whom he is voting for, at least he will stay on for 5 years to serve the constituency. Because after all, every constituency is represented by, no matter who the leader is, he is a candidate of that constituency, he is going to be representative of that constituency. Therefore, I think from the purely voters' perspective, that the choice must be very clear and the choice should not go waste.
Okay. Okay. You want to...
I think one suggestion which has not been voiced but probably can be thrown on the table, that all right, we have decided that it is always the big leaders who indulge in this. All right, if you resign from that constituency, let their runner-up be declared the winner.
Okay.
Let them accept that. No re-election, no nothing, and
that's a suggestion which has not been officially made by the Election Commission on record. So clearly, but there would be a lot of suggestions which would be coming in. Last word from you, Mr. Malhotra, before we wind this up. How do you see this moving ahead in the future, apart from the fact that all three of you have pointed out that it would be done under the public scrutiny only, maybe when the public voices its concern and the voters voice their concern? But from a legal point of view, which route do you see this taking now?
You see, talking about the electoral reform, it is an ongoing process. It is not that it has not happened in the past in piecemeal. I think even in piecemeal, if there is a necessity, even today also steps can be taken, and not necessarily that it should wait that, okay, let us repeal the old law or bring a new law. If in piecemeal also some reforms can be brought, and it is in the interest of the public and in the interest of the democracy, the step should be taken, and Parliament is meant for that.
Okay.
And that is what is happening even today. It's not necessary. Take for example, the new laws which have been passed. Even if there are deficiencies in the law, every day we are making amendments and bringing improvement, be it insolvency, bankruptcy code, be it your GST. Similar process can be adopted even with regard to the electoral reform also. And if this is a proposal which is pending for such a long time, and in the affidavit which the government has filed, they are taking a particular view, let it be debated in the Parliament, and let the political class as a whole take a view whether the stand being taken by the government should be accepted, or the view which has been taken in the public interest litigation and pending before the Supreme Court. Before the Supreme Court gives a decision, let the Parliament take a call and say that, yeah, well, it should be done.
Okay. Mr. Iyer, one last word from you as to how do you see this moving ahead, and is it possible to go ahead and look at the electoral reforms in a piecemeal manner rather than taking them in a holistic perspective and moving ahead?
Well, I think this is one reform which is easily doable. You see, compared to others, which is much more complicated or to require greater consensus, this is one thing is doable, and one that goes in a long way to contribute to free and fair election process. I think on that, perhaps the political parties could initiate debate among themselves, because if this is brought in, then everybody is at equal footing. I mean, no party is going to get an advantage or a disadvantage. So this is a doable thing. And I would agree with Mr. Malhotra that we have seen instances where a lot of things have happened for curbing money power, for muscle power, even the introduction of EVM. That was also possible because of political parties, agreeing to it. Though at different stages they have had their apprehension.
Okay.
Therefore, I would look forward to a situation where parties can actually sit together and look at this issue.
Okay, so clearly it looks like, as our panelists have also pointed out, that there are ways and means to go ahead and implement suggestions like these, and perhaps the pressure from the public or from the voters who are going to go ahead and cast their vote in these elections might go ahead and play a very important role. But ultimately, the final call rests with the Parliament, which is supreme in terms of enacting laws and amending them. We'll come back again tomorrow with a different topic and different set of guests. Till then, keep watching Rajya Sabha Television.